So you're humming along building data centers or whatever, and things don't go well, and you're not making money, and you need to close up shop, and the investor money is gone, and but you really want to stick it out, so you need to make payroll. So Chris, what do you do? Okay, here you go. I'm going to do, multiple choice. All right. What do you do, Chris? All right. A, do you go back to your investors and ask for more money? Okay. B, do you go to the bank and try to get a working capital loan? Or C, do you transfer what's left in the corporate bank account to DraftKings and put it all on a Super Bowl prediction? A, B, or C, Chris?
Not the last one.
Welcome to episode 110 of the Weekly Docket, a podcast by the Silberman Law Firm where we talk legal news and practical law. Today is February 20th, 2026. I'm your host, Phil Silberman, owner of the firm, and I'm joined by Chris Heald, who's the firm's supervising attorney, and my co-host. Chris, do you have a favorite close to your letters? Now, I did not know this, but it was called a valediction. And I don't know if you knew that or not, but that's what it's called. The thing that's like sincerely, right?
So, well, I knew there was a salutation, so I knew there had to be an opposite of salutation. I may not have been able to come up with that one if you gave me 10 guesses.
Yeah, no, it was learned something today. But yeah, so valedictions, if you're writing a demand letter, or how do you like to end it as an attorney? Do you just something boring, just like regards, right? I mean, that's how I end mine.
No, as you know, when I was formally trained, everything had to be a certain way. And it was, one, we did it at the firm all the same way. And two, it was really ingrained that you don't just haphazardly do it. Everything is done with purpose. This will be the valediction on every letter you ever send out of this office. So it was very truly yours. That is how every single letter was always signed by everyone. So I grew accustomed to it. I do like uniformity in law firms. I do like everybody doing the same thing. It promotes the brand. So that's always been mine.
I feel like you've just stifled my creativity for like the rest of the day with that story. Like a very depressing, like a bunch of lawyers like working. You shall all have the same closings to your letters. I'm like, well, what if I want something else? I mean, like, Chris, what do you think about, it's a really forceful demand letter, and you want to end it with govern yourself accordingly.
Well, that's a funny one that one of our attorneys got several years ago. And so we joke about that, but you can put that in the body of the letter. You can put that in your closing. But if that end part is always the same for everyone, again, I like the uniformity. I don't like, everybody having their own style. Some people put by, some people put for the firm, like, all these technical things. But again, you're not one on technical things. You like creativity. You encourage everyone to be creative.
Well, I mean, you could also close in the alternative. You're like, very, very truly yours. Alternatively, govern yourselves accordingly, right? As attorneys, we like to do things in the alternative. It's the old saying, boy, I wish I had an attorney with only one hand, right? So,
yeah. My favorite of all time, though, to be on the recipient's end, was no joke. It was, I am, comma.
Well, that's actually blasphemous. It was surely it wasn't like a capital M. Am I like, it wasn't like,
just I am, and then the person signed their name.
That's
like, I can't imagine signing off my letters. I am.
Well, there was a gentleman, who did that about 2,000 years ago. And I don't know that he signed any letters, but he made a great statement, and some of my listeners will understand that reference. But we have to move on because
I'm with you. But yeah, not to get too far down there. Like, does it kind of make you cringe a little bit that all these athletes say, I'm him? That I don't love that.
I didn't know the athletes were doing that. I did know the athletes would quote a verse of only partially, which is I can do all things. And they leave the important part off, right? Which is the operative part, right? It's kind of like it's like, yes, you can skydive, but you can't skydive without a parachute. I guess you can, but you'll only skydive once, right? So
That is true.
all right,
That is very
we
true.
we gotta move on.
We're off the rails already.
Way off the rails. All right, let's talk about what's on our docket today. We're going to talk about what not to do when your business is in trouble and you need to make payroll. All right, that's going to be topic one. And then in our legal question section, we're going to talk about doing commercial lockouts, landlord commercial lockouts, and some strategy there. And then we will debate the age-old question, Chris, of the chicken. Now, I'm not talking about the chicken or the egg, which comes first, Chris. I'm talking about much, much more important. Is it a wing or a nugget? All right, that's in our rant and rave section. So,
Love it.
all right, let's go ahead and get it kicked off with the payroll issue. Now, this was a real call. I don't know if I was very convicted about whether to do this piece or not, because again, it's a real call. And I think the gentleman is considering hiring us. And a lot of people that think about hiring us, Chris, they listen to the show first, right? A lot of people who consider working for us or hiring us, they will listen to the show. So I don't doubt that there's a high probability that he could be listening to the show. So if you are out there, please do not take offense at this, and know that, that the details of your case would always remain confidential, and we don't judge you for anything. We have a lot of clients that make some less than stellar decisions, and we are here to help. But so anyway, we get a call, or I get a call, and the guy's getting sued. It was a construction company. Business did not do so well, and the construction company went out of business. It's not a big deal. It happens. You start an LLC, you got a couple of members on the LLC that are the money guys, and they put in a couple $1,000,000 or whatever. You're the muscle behind it. You're the labor, you're the builder. And I don't know the exact facts of this gentleman's case, but you just fill in the blanks with stuff like this, right? So you're humming along building data centers or whatever, and things don't go well, and you're not making money, and you need to close up shop, and the investor money is gone, but you really want to stick it out, so you need to make payroll. So Chris, what do you do? Okay, here you go. I'm going to do multiple choice. All right, what do you do, Chris? All right, A, do you go back to your investors and ask for more money? Okay. B, do you go to the bank and try to get a working capital loan? Or C, do you transfer what's left in the corporate bank account to DraftKings and put it all on a Super Bowl prediction? A, B, or C, Chris?
Not the last one, but I thought you might be going there, because I think the owner of FedEx famously did that way back when, like took the last $50,000 in the bank, went to Atlantic City, had a good streak in him, made payroll, and then was able to secure more funds.
Okay, so that's like a happy story. That's a happy story where nobody sees you and you're not FedEx, right?
Like for every one of those stories, there are 20 or 30 or 40 that don't work, because
I actually did not know that was a thing. We're going to have to fact check this. I think,
if it's not FedEx, then I apologize. I think it was FedEx, but you'll find the story that the CEO like took the last 50K in the bank and went to
well, FedEx says, I think the founder of FedEx was Fred Smith, and he was in business school, and everyone had to turn in a project for a potential business. And Fred Smith turned in the FedEx, business plan. And the professor gave him a C on it. And he said, Freddie boy, and in order to get anything higher than a C, the business actually has to be plausible. So there you have it. There you have it.
That's a brilliant story.
But
anyway, don't go gamble corporate funds. I would imagine, and maybe I'm just pulling this out of the air. You tell me if I'm wrong. I've had friends in the oil and gas industry. The company goes under, And, they come to me and they say, hey, how do I get my last paycheck? Well, I understand the spot you're in. That's going to be tough because the company owes you the money, but the company doesn't have any money. And he's, oh, but I know the CEO has $10 million. Yes, the CEO does have $10 million, but I don't think you can make that CEO pay you money. If that CEO took the money and put it in his DraftKings account, then I think you have a little more plausible of a claim. But if the company just runs out of money, payroll's a liability just like any other liability. You can come to the window with your hand out and say, hey, I'm a creditor, I'm owed money. Probably not going to work out too well for you, though.
Yeah. I want to point out that just operating a failing business and trying to save it is not necessarily illegal when it goes under. You haven't violated any law. If you've in good faith as the president of the company tried to run the construction company and it just wasn't working despite all your best efforts, your members who are the money guys don't just to get to sue you and say, hey, I want my money back. That was part of the risk. It's like when you invest in Tesla and, Elon Musk decides he's no longer a car company and he wants to be a robot company. If that fails, if that doesn't work out, you don't get to just say, hey, give me all my money back. Right now, the important thing here is Elon Musk or whoever the president of this construction company is, they're not allowed to personally enrich themselves. They don't get to take the money and buy Ferraris as the ship is going down and take all the money. That is fraudulent, and that is going to open yourself up to liability. Now, Chris, I had not thought about this until you mentioned the alleged example of the CEO going and actually to Atlantic City, actually winning, making payroll, and going on happily ever after. But do you think it matters whether the money is transferred from, I don't even know if you can have a corporate DraftKings account. And let's just assume you can. All right. If you transfer the money from a corporate bank account to a corporate account for gambling and you make some relatively, gambling is risky, but you make some okay bets, not crazy bets, and you just lose. Could you make the argument that that was a viable plan to make payroll and you don't get to sue my guy for fraud? I mean, do you love that or hate it or?
I could make the argument. Well, I'm a gambler. Tesla owns Bitcoin. It's on the books.
Mhm.
Tesla owns a lot of investments. You've got Kalshi and Polymarket and all this stuff that, they're now making everything legal, even though gambling's allegedly illegal. We just like fantasy sports 10 years ago, we found ways to make it a tradable commodity. And we just don't call it gambling, even though everybody knows it's gambling.
Mhm.
So with the way these are moving, with these actually being purchasable equities, you could make that case. I don't love it because courts have ways of getting to the result they want.
Mhm.
And so if they see that, oh, you just put all your money on the Patriots and that was a stupid bet, your investors are going to get mad. It's an easier sell than what you just pointed out, whether they're personally enriching themselves and saying, oh, no, I need a plan. I need a Ferrari. I need to keep up the brand. Or what we run into a lot, like you said, we get in housing investors and the project just doesn't work. Well, that happens. COVID, material prices, things can happen. But if you're specifically taking money from one investment project to go finish up the last one you had, and you're like, well, I'm just going to sell that one, then it'll bring the money right back, and then I'm going to pay my investors. Except that doesn't work. And then you're eight projects deep. Oh, let me finish the last one, get the money, pay the investors for this one. It starts getting really ugly.
Yeah. Well, you're opening my eyes, Chris, to really a world that I don't know about, because when I first heard the call, my initial reaction was, gosh, this is really bad. If you hadn't told me that, I feel pretty good about a traditional summary judgment case where it's just, hey, I did everything right. Business didn't work out. As a matter of law, there's really no basis for the actions. I didn't commit any fraud. And then when he told me that fact, my reaction is this could go to a jury because we've got just the gambling kind of thing. That's enough of a fact to allege But now I'm thinking, even if it does go to a jury and you've got 12 people, Chris, in Harris County or Dallas County or Travis County, you pointed out, rightfully so, how mainstream Bitcoin has become, and which is a form of gambling. Make no mistake about it. Okay. Or how mainstream these poly market or whatever that is, if it's a couple, all of this has become. So now you've got 12 jurors and, they're going to be very receptive, maybe more receptive than a 1996 jury panel. Right. So, hey,
For sure.
guy out there, if you're listening, call me back. Right. I feel much better about your case. We love you. You're a nice, well decision making guy. Right. So, all right. No, don't but Chris, just on the record, you're not encouraging our young entrepreneurs to do this if they're having trouble making payroll, right?
Correct.
Yeah.
Yeah, let's get that out there. And, if someone makes a mistake and wants representation, that's a far cry from if someone's about to make a decision and I have to say, listen, as counsel, I cannot advise you to do this.
Right.
Your investors are trusting you to invest. They're not just giving you free reign to go do whatever. Like, I knew about this altcoin that was going to 100x over the next month. Or I knew, the 1996 example would be the third horse in the sixth race. I got this hot tip. He's a 4-to-1 or he's a 10-to-1 long shot, but it's a sure thing. So I'm going to go put my money down at the window.
Yeah. Well, okay. There you have it. I mean, let's not do that. People don't go with the option C or the gambling option. Go with try to raise some more money or maybe get a loan. Of course, you're probably not going to get a loan. So, it's running a business is hard. All right, we got to move on. How do you stop a commercial lockout? Chris, real quickly, this came up I don't know if you've been following the legal chat room with all of our lawyers today. We've been active in there this morning and answering questions about Chris is grimacing, but don't worry, Chris, I've been supervising.
I've been working on a business transaction that you're have been doing that all morning.
Okay. Well, and that's a very, very good use of your time. Unlike, some things like practicing mundane areas of the law, what we need to have our very astute young associates do more of. All right, look, simple. We represent a tenant, commercial tenant. They're having a dispute over over who's responsible to pay property taxes. In commercial tenancies, it's not unusual for the tenant to pay property tax. That's a form of a net type of rent as opposed to a gross base lease. Now, what if it's a good lease and you had lawyers do these things? This is going to be very well spelled out with no ambiguity. In this case, Chris, they used the Texas Association of Realtor form, and they didn't fill in blanks correctly and left some of the blanks incomplete. And you certainly have some ambiguity. All right. So you've got this dispute over who pays rent. It's about a $30,000 dispute. And the other side fires off a letter saying, hey, we're going to lock you out. Right. Let's assume they go through the commercial lockout process correctly. It's not that hard. Post something on the front door, you're locked out. What is the mechanism, Chris, for getting, this was the associate's question. What's the mechanism for getting my tenant back into the space?
A writ of re-entry.
Writ of re-entry is for certain the cause of action. And procedurally, you could probably also do it in a deck action, declaratory judgment action. But the actual procedural mechanism, Chris, you know this, you've done hundreds of these. It's the temporary restraining order, right? So you're going to file the petition and you have to file the application for the restraining order to return the status quo and get back into the space, right? We agree with that?
I think we got burned on it. I think you have to file a writ of re-entry. I don't think it's a TI. I think, or a TRO.
Okay.
I think we're told that was not how you do it. I think you have to do a writ of re-entry.
Okay.
It's chapter 93, I think.
Yeah. Yeah. We have that. Maybe you're right. We have that too. My initial inclination was the TRO. And it came back. Actually, we popped it into AI and the AI kind of confirmed the TRO. Not that AI is the correct thing, but then it also brought up the writ of re-entry. So I was going to plead the petition with the cause of action as a writ of re-entry and a deck action, and then ask for it in the TRO. But you're saying maybe there's a procedure in the property code that allows you to go through. Okay, and that's
little recollection, and we can check with the associate that did it, because we were talking about it every day for a long time, and we were going through Chapter 93, but we did a TRO, and the judge, my recollection is the judge kicked us out and said, "This sounds like a writ of re-entry. Why am I hearing this?"
Okay.
I think the TRO would be appropriate if the lockout had not yet occurred.
I see. Okay.
Already getting locked out, because like you said, commercial is much easier than residential. Residential, you're not really supposed to lock people out. When you do, you have to give them the key right back.
Okay.
In commercial, you can lock people out, and then you have to file the writ of re-entry.
Right.
But it's definitely much more complex, and we were not successful. So it's a challenging area of law for sure.
Okay. So this is great, because the listeners can kind of hear how this dialogue goes. I thought, well, surely it's a TRO, and then I was going to do it one way, and Chris said, no, I've been down this road before. I think it's this. And now what would happen if we end up, actually proceeding on this case? Someone's going to actually check the code and see what the mechanism is, so you don't get all the way down there and the judge says, no, and then you have to go back out, redo the whole thing over, and the client's not happy. But it's always good to have the correct law when you go in the first time. So yeah, I mean, that's either one of those two things are going to work, and that's how you do it. But there are some statutory damages with the writ of re-entry as well that I did see, which is 1 month's rent plus $1,000. So, and then I wonder if there's a bond. The TRO process has a bond, right? So if you're in dispute over $30K, I assume that there's going to be some requirement for a bond. But maybe that's not in the cause of action writ of re-entry. So
I'm not sure. I don't recall.
Got to look at that. All right, let's go to move to the next part of the show. My favorite part of the show, rant and rave. Wings or nuggets? Chris, you eat wings, right?
I know where we're going with this one.
Okay. Well, have you seen the recent lawsuits?
I just saw the answer, and it was exactly what I expected.
Okay.
Yeah.
Well, so you did look at the outline.
No, I looked at, I know that somebody sued Buffalo Wild Wings because they're stupid, because people do stupid stuff like sue Subway and say, oh, this isn't a 6-inch sub. And they're like, it's a sandwich. You know what you're buying. Either buy it or don't.
Okay. So you knew about this one, and
I knew. Yeah. Some idiot decided that this isn't fair. Like, if you don't like it, don't buy it. Just go home.
Look, Buffalo Wild Wings. I mean, you got to set it up. You got to give the listeners.
I'm
You
sorry.
got to give the listeners the background. Okay. Buffalo Wild Wings. They're humming along, selling wings, right? I did not know this, Chris, until I went to one with you at some point, or maybe we went to a Pluckers, and you ordered some wings. I just assumed naively that you were going to kind of do the thing where you hold it up and you delicately use your teeth to eat around the bowl, the bones. And, you order them extra spicy with, soy sauce and glaze and honey mustard or whatever. And you just start popping and I'm like, well, there's a bone in there. And you're like, no. And I said, well, that's a chicken nugget. That's a chicken nugget, right? Clearly that's a chicken nugget. A guy in Ohio, I guess he's in Ohio because this came out of the Ohio courts, sued Buffalo Wild Wings saying, you're deceptively advertising the food that you're serving as a wing. It's actually, in fact, a chicken nugget. The judge, this is my favorite part, Chris. The judge dismissed the lawsuit, calling the claim meatless.
No. And I didn't read the opinion. I read that it was one of those 10-page opinions that is full of stuff like that.
You got to have a good time with that, right? So if you're a judge, because you don't get that opportunity teed up very often. Fanciful names. The judge ruled that the boneless wings is a fanciful marketing term. It's been common use for decades. Context clues, okay? The court also noted that Buffalo Wild Wings sells cauliflower wings. A reasonable consumer understands that the wing refers to the sauce and preparation style, not the anatomical part of the bird. Okay, so and
Well, they're called buffalo wings. They don't come from buffalo. So
yeah. I like this part of it. I like this part of it too. The hamburger defense, right? Consumers know that it's actually similar to the chicken finger. The judge noted that consumers don't expect hamburgers to contain ham. So, or Chris, buffalo wings don't actually contain buffalo meat.
exactly.
Yeah. And on that note, Chris, as serious as this topic was, we have to bring our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host and resident expert on writs of re-entry and buffalo wings.
And chicken wings,
Right,
for sure.
right. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice, and this is all meant for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com. That's info@silblawfirm.com. And tell us you want it publicly answered in the podcast. Everybody have a great rest of your Friday and weekend.